29.
Serial number appellant, my lord.
So what do you want?
Adjournment.
It will go beyond vacation. At the request of learned appellant, stand over to 24th of June.
Serial number 22, my lords. Serial number 22, my lords. I'm appearing for petitioner, my lords. Praise for
Yes.
short accommodation.
Time.
22, my lords.
Same order at the request of petitioner, stand over as requested. Stand over to 23rd of June as requested by the petitioner.
Lordship, serial number 26. Your
Yes, Mr.
My lord, one matter has been heard by the dishonorable court in part. The LCR is required. That's why I'm move for memo. Government advocate secure the records. LCR is a must, my lord.
What?
LCR,
What
lower
is
court record, land tribunal record.
So
One matter has been heard by dishonorable court in part,
Huh.
and matter has agenda on 2/4.
it can't be like that.
Lord, this is a case where my lord,
File whatever application you want to file.
Lord,
My-
A memo record can be called.
Lord, here is a case, my lord, NIA matter, my lord, it has been filed in 2023 December, my lord. Bail matter. As of now, my lord, it is not believed because special bench have been constituted by lordship in January 2024. Lord, as of now, more than 20 memos have been moved, but it has not been listed. It's a bail matter, my lord.
Bail matter.
Bail matter. It's a-
Then go before the bail court.
No, bail court, my lord, it's bench is specially constituted. It's a national investigation agency matter. An appeal was filed, rejection.
Approach the learned research.
I requested, your lordship has already directed me to approach the registrar. Even I have registered 20 times, but it has not been disturbed because we have a special bench.
I'll look into.
But,
I'll look into. Memo is not necessary.
otherwise,
Just-
my lord, otherwise, my submission. But 1 year, 4 months has been completed.
Saying that we look into, you just give details to the court officer,
Yes,
details of your matter,
Yes.
not by way of memo.
yes.
Yes, that's all.
My lord, if I'm
25, your lordship.
25, yes.
Short accommodation, your lordship. We have filed for documents via RTI. We have not.
Regarding
received
that,
it.
height,
No, your lordship. This is a different PIL. This pertains to Bangalore flower merchants. There has been illegal construction in the fire safety places. Pertaining that, we have applied for documents to RTI.
7th of April,
Ma-
Serial number 26.
26.
26. Time.
It will go after summer vacation. At the request, as requested by learned advocate. You are Miss Monica Patil. Monica Patil, stand over to
my lord, if I may
4th
move
June. 4th of
this memo for posting.
Serial number 40.
40.
40.
Yes.
The complainant, the little inconvenience, the short accommodation in the ground.
It can go after summer vacation. 3rd of June.
My lord, if I may move this memo for posting, the matter was posted on 24/3, but it couldn't reach due to paucity of time.
Some
20
date must have been given.
28 was given, 28/4, but the father hasn't met his child from 5 months and he's desperate to see his child, my lord. If it may be
Posted
taken
to some date today.
on 28/4.
Then you file IA if you want to prepone the date, not by memo.
Lord, serial number 37, my lord. I'm appearing for the accused number 1, my lord. I want to file wakalat on behalf of respondent number 1 is concerned, my lord. Have it on, my lord.
Whereby 200 plus customers are waiting for registration. The order in contempt, my lord, has been passed last year, under which they have still not complied with the order, my lord. And because he could.
Date, my lord. Next week, my lord. Any date, my
Let
lord.
him file wakalat.
Please, my lord.
4th,
Today, my lord. I will
Fourth.
undertake to file.
4th,
Please,
4th April.
please.
You file wakalat by
Today itself. Please.
Yes, Mr.
My lord, with Lord's permission, I'm mentioning a matter, writ appeal number 310, fresh matter, my lord. Very urgent, because based on the impugned order, the respondents are colluded here, and they are trying to forcibly take possession of my property belonging to the appellant hospital. It's listed today.
Today not possible. 3rd.
Then-
3rd of April.
Heard of.
The lordship, this is again a memo for posting. because 60 families are suffering as a result of this uncertainty in the building. So I've just requested either on the second or third, Your Lordship.
What is that?
This is CCC 217. Yesterday it could not be heard.
Oh,
So I'm just requesting.
so
an
date
early-
must have been given. Which date is given? 28th of April.
28th, Your Lordship. The problem is my mother will not be here. So I'm requesting an early date if possible.
Then file interim application. Not by memo. Date given judicial side, judicially cannot be preponed unless you file application. That is the rule of this court. You file application, not by memo. You move an application for preponement on valid grounds.
Recording that submission, that contempt petition is dropped. Now, my lord, even after lapse of 4 months, my lord, they have not done it. I have filed an application, my lord, seeking revival of that contempt petition before your. lordship.
Seeking withdrawal,
Revival.
revival. All right.
Monday.
No, 8th of April.
PIL filed 2020. I am an allottee. That respondent is the before respondent file an application. That she is a bank employee, that she is about to retire. The construction was stopped. The PBFP would have identified all the serious rates and parks. Now that my site does not come under the park area. That file an application. That she obtained a loan, 70 lakh. That when you started the construction, at that stage, it is interrupted. That file an application. They have submitted all the reports. My site does not come under the either part or CA. Now file an application for modification of the interim order. Because she obtained 70 lakhs the
17th April.
Lord, yesterday matter was heard for at length, my lord. Be permitted to file this. I'll serve the copy through email. Physically also, I will serve the copy right now.
This yesterday's matter.
Yes, sir.
Huh? 19, yes. There is a delay of, we'll issue notice, delay of 86 days, notice returnable on first week of June. Tenth of June. Notice written 10th of June.
Lord, serial number.
Your
20.
Lordships, if I may mention serial number 52.
Respondent for the 52, my lord, serial number 52.
Yes,
Lord,
I
serial-
appear for the appellant in serial number 52, Your Lordships.
Serial number 20, my lords. I request
21,
to-
yes. What do you want?
I request a week's time, my lords.
No, no, what is this PIL?
In these matters, my lords, Rule 36 of the KMMC rules are under challenge, my lords.
Oh.
Validity of the rules may be heard after vacation.
8th of April.
Please.
Yes, Mr.
Your Lordships, serial number 52, if I may be permitted to mention, I appear for the appellant in this matter. The respondent has filed the reply to the petition only day before yesterday. I will need some time to peruse that reply. I am seeking for a short accommodation.
Serial number
52.
52, my lords.
If there is no urgency, let it go after.
Please.
2 weeks' time, my lords.
And as good as 11th June.
The interim order may
Yes.
be extended, Your Lordship.
In view that the pleadings are served yesterday, full stop. Interim order already operating shall continue to operate till the next date.
Much.
Any other mentions to this?
Make it 12. 12.
Grant permission.
Seal number 1.
May I appeal for the appellant, madam. My sincere apology, my
this
lord.
is the
Yesterday
matter
the
that
case
was-
was caught. I was not present, my lord. My sincere
Doesn't
apology.
matter, yes.
Matter was heard day before yesterday, my lord. This matter relates to compensation for rehabilitation, my lord. The members of the families have been compensated. The writ petitioner had claimed compensation on the ground that he resides separately. So the lordship had gone, the question of family definition, my lord, under the scheme.
Yes.
My lord, in the course of hearing, my lordship was pleased to post two clarifications, my lord. Whether the joint family property was subject matter of partition much prior to the land was acquired. Second thing, my lord was pleased to refer to the PDS card, ration card enclosed by the appellant, my lord. There the name of all the family members are mentioned, my lord. And I would like to place on record the clarification regarding those 2 points, my lord. May I pass over the copy of the registered partition deed, which was effected much prior to the land was acquired, my lord.
You will be appearing for all.
My lord, I'll be appearing for
State respect.
state, my lord, respondent number 1, my lord. 2, 3, and 4, my lord, all the respondents. please.
Oh.
Lord, insofar as this
Let me
partition is
Make
concerned.
submissions, my lord.
Hmm.
And insofar as the PDS card is concerned, my lord, the acquisition proceedings is of the year 2000, my lord.
Hmm.
Rehabilitation resettlement scheme was adopted by the state government in the year 2001, my lord, as per the government order, my lord. The ration card at page number 75, my lord. This is of the year 1995.
Yesterday.
Prior to the acquisition, my lord. This is of the year 1998, 6/5/1998, my lord. Pursuant to this partition, my lord, the ration card was changed. Please, I'm the father.
Father.
Please, I'm the father. My children are given the land, not all the children. No, 2 children are given the land, my lord. Please, they were residing separately. They were residing separately, my lord. And they were considered a separate family, my lord. Please, my lord.
Area,
One-
area.
one
Size of the land, plot, size of the plot. What is the size of the plot there?
for my, given to the children, my lord. 40-50 site was given, 1 acre of land was given. As per the rehabilitation settlement, they were entitled, they were given the benefit, my lord. They are living,
Settlement is there on record?
please, my lord. Not
Rehab-
rehabilitation resettlement scheme, my lord. As per the scheme, they were,
That scheme is on record?
please, my lord, I kindly consider, my lord. Page number 62, my lord. Page 62. Above that tabular column, cost of rehabilitation as per the proposed new rehabilitation package. And serial number 1, ex gratia payment for displaced families in bracket 736 families, kindly note. And the third serial number, my lord, transportation cost of 5,000 per displaced family, number of families is 736, my lord.
Where you are reading?
Please,
Ah,
my lord,
yes.
sorry, my lord, page number 62, my lord,
Yes.
in the tabular format above.
So each family is defined somewhere?
Defined, my lord, in this.
One, I'll submit, my lord.
Lordship may
And
have the
so far
typed
as
copy, my lord. page
definition
number
of the
66.
family is concerned, my lord, kindly at page 65, my lord. Page number 65.
Type copy is also there.
Typed
Yes, I
copy
have
from
also
66, my
enclosed a
lord,
copy.
page 66.
66.
Please.
My lord, there it is mentioned, each family to be treated.
Where you are?
Page 72, my lord, definition of family, class F, page 72.
Page number 72 typed copy,
Class F, my lord.
the tabular format clause F.
70 definition of.
Each family to be treated as a unit for the purpose of rehabilitation grant and distribution of sites. And families is limited to, number of families is limited to 736, including landless persons and encroachers. My lord, in the rehabilitation scheme, my lord, it is specifically mentioned that this order is confined only to the 736 families. And the benefits,
Today you are residing separate.
my lord, I am residing separately, my lord. In the ration, my lord, on last Monday, my lordship was pleased to observe that in the ration card, name of all the children are mentioned. That means that you are residing in the joint family, my lord. For that purpose, on previous occasion in the writ petition was also the same contentions was urged, my lord. However, I could not place actual facts before the honorable court, my lord. Kindly consider page 76, my lord, the extract of the ration card. But it is in Kannada, my lord. I have filed the English translation also. For the
70?
sake of submission, this submission, my lord, 76 kindly be considered.
Yes.
At the right hand, my lord, there are entries in Kannada. 1, 2, 3 entries are rounded up.
So translation is there. No?
In the translation, I have not rounded up.
So 2
In
is
the-
rounded up to 5
Ramamani, Manjunath, Jayamma.
and 7.
Please, my lord.
So Ramamani, Manjunath or what? Manjunath is rounded up or
Manjunath, serial number.
Chandrasekhar.
Please, they are rounded up.
Manjunath is rounded up.
Manjunath rounded up.
Manjunath.
Jayamma also rounded up, my lord.
Who?
This is of the
Who is rounded up?
the
Venkatta.
No, my lord.
separated children are
Ramamani.
rounded off. Manjunath has been granted the benefit, my lord.
Now, 1 second.
No, rounded off is Ramamani, my lord, Manjunath and Jayamma. 3 of them are.
And
Jayamma.
where is Jayamma?
Jayamma is
Number
age 17 years.
Remember?
Serial number 6, my lord. 6, serial number 6.
Acha, Jayamma. So
My humble submission, my lord.
Venkatesh is not.
Please, my lord.
Venkatesh is not rounded up
Not rounded off, he is taken the
Still
benefit.
staying with me, my
all life. So
my lord. Serial number
1 second. Manjunath is son.
son,
Rama
daughter.
daughter.
They are married, my lord.
Daughter.
In the partition deed also, they have not taken any
Married.
property.
Manjunath is son.
Yes.
Please, son.
And this
Venkatesh.
Jayamma
Jayamma, daughter.
also daughter. So who has got right now?
My lord, I am staying with Krishna.
Who has got the site?
My lord, Manjunath got the site, my lord.
Manjunath got.
My lord, this ration card entry is of the year 17/11/95.
You are Thimegowda.
Please, ma'am, Timmegowda.
17.
17/11/95. Initially, it was issued on 95, ma'am, in the year 95.
Acquisition is
Acquisition in the year 2000.
2000.
And this was round of entries were made in of the separation of
Who
the
is
joint family
Who is
status.
Huama?
Please, my lord.
Huama.
Uoma is daughter.
Huama is also Huama is wife, my lord.
Wife. And Krishna?
Krishna's son, my lord.
Son.
He is residing with me. He was the elder son at that time. He was about.
So only Manjunath has got the site.
Please, ma'am.
Only one.
Manjunath got the site.
No other.
Manjunath,
No.
You said two sons are given.
please, madam. Manjunath and Chandrasekhar.
And Venkatesh, all the 3 got it.
Chandrasekhar is also given.
Venkatesh is also given, my lord. All the 3 got it. Lord, statement of objections have been filed, my lord. Page number 102.
My lord.
As they constructed which larger ratio become smaller. What is the survey number which was acquired here?
My lord, as per the partition deed, my lord,
What is the survey letter?
Uh,
Land details are.
survey number, I have not taken any portion in the survey number, land, my lord.
One,
I was allotted a house. House was allotted to my share in, as per the partition, my lord. That house was built on the government land, my lord. In fact, as on the date of acquisition, I was a landless person. That was fairly considered by the forest department, my lord, as assistant conservator of forest, while forwarding the report to the deputy commissioner on the basis while considering my representation for grant of the land, my lord. I have filed the copy of the same report filed by the ACF, my lord. Kindly consider. The notice issued by the ACF is at page 112, annexure G, my lord. It was addressed to the appellant. And annexure J at page 117, that's the report forwarded by the Assistant Conservator of Forest and Director of Bhadra Wildlife to the Deputy Commissioner. That is dated 5/2/2015. There they have mentioned that the appellant should have been considered as a landless person and project displaced person, and accordingly he is entitled for grant of one site and land, my lord. Page 118, my lord. My lord, it is not the case either in the impugned order or the stand taken by the state government that siblings, parents, and or the blood relatives are not entitled for grant. It is not their case, my lord. Learned single judge was pleased to consider the fact that similarly placed persons, land has been granted to the blood relatives, including siblings and parents, my lord. That is part of the impugned order, my lord. However, in case of this particular appellant is concerned, my lord, factual issues pertaining to the appellant's position as a project displaced person and for his entitlement for grant of the land was not fairly considered by the learned single judge or even by the deputy commissioner who issued the endorsement during the pendency of the writ proceedings, my lord. In the endorsement issued by the deputy commissioner, the same is not supported by any factual matters, my lord. Kindly consider the endorsement, my lord, at page 172. (171) is the Kannada, 172 translation. In the endorsement, it is mentioned that all the benefits have been given to the family members, and your case cannot be considered as you have approached after lapse of 14 years after finalization of the scheme. In fact, my humble submission is, my lord, there are many writ petitions are also pending before this honorable court, my lord, and on about 2-3 years continuously, my lord, separate directions have been issued in different writ petitions for grant of the land, my lord. The scheme has not yet been finalized, my lord. It is not effectively implemented. In fact, a committee has been formed under the chairmanship of the local deputy commissioner, my lord. They are also considering the directions issued by this honorable court, my lord. My lord, my submission is, as per annexure F, page 98, my lord. Translated copy 103. Page 98, my lord. My name is mentioned at serial number 1. Page 98. This is the details of the payment of compensation of houses situated in government lands in the villages under Bhadra Wildlife Sanctuary Scheme. Page 103, my lord. Serial number 1 is KP Thimmegowda, the appellant here. And my son's name is mentioned at page 9, at serial number 44 and 46, my lord.
serial number 50.
44, my lord, 46 and 50 KT Manjunath, my lord. My lord, this amount has been paid as per the very same rehabilitation and resettlement scheme. For the purpose of granting the compensation, I was separately considered as a project displaced person. Kindly consider the contradiction, my lord, in so far as the contentions urged by the state is concerned. My lord, all the beneficiaries whose names were mentioned in the said list, they were given the benefit of a grant of one site and land, my lord. My humble submission is, let them consider, reconsider, re-verify whether factually my claim is genuine or not, my lord. Let there be an application of mind, my lord, at least. To that,
So for orders on 8th.
Lord, one
my lord,
submission, Lord,
one
regarding the.
submission,
I'll make a-
I will, on previous occasion, my lord, I made the submission for disposal of the appeal, my humble submission, request, my lord. I may permit to read the memo also, my lord.
We'll read it.
Please.
Pass it. You, they copy to Mr. Harish. You copy to other side.
It's
Yeah, what are you producing?
I'm not producing
Some order.
memo.
Alternative prayer, my lord. Lord, only a couple of submissions, my lord. One is in relation to the partition deed, my lord. There is no averment in the writ petition or in the rejoinder file before the learned single judge about the partition, my lord. There is no reference to that. Secondly, my lord, we have filed a statement of objection. Lordship may kindly see paragraph 5, 6, and 7, my lord. Who are all the beneficiaries? Paragraph 5, 6, and 7 of my statement of objection, my lord. If your lordship permit, I will read. It's a short paragraph, my lord. Paragraph 5 is about the ration card and the family members, my lord. Paragraph 6 says, my lord, it is submitted at the land of the petitioner's family bearing survey number 46, measuring 1.35 acres situated in so-and-so village, which stood in the name of petitioner's son, KT Manjunath, Chandra, KT Venkatesh, each 0.25 guntas, was acquired for the above said project. The preliminary notification under section 4.1 of the Land Acquisition Act shows the Katedar as KT Manjunath, KT Chandra, and KT Venkatesh of the above said land at serial number 46. Copy of the notification was produced. It is submitted that in lieu of the above said acquisition as per rehabilitation scheme, 1 acre of wetland was granted to Manjunath in survey number 12, 1 acre of wetland to Chandrasekhar in survey number 3, and 1 acre of wetland was granted to KT Venkatesh. Since the family is treated as one unit, the copy of the Hakku Patra is produced. So 3 sons are the beneficiaries, Malaya. Their name appeared as the Katedar. As per the notification, we have gone by that, my lord. In so far as the writ petitioner is concerned, my lord, the scheme is of the year 2001. The requisition made by him as per page number 172, my lord, is in the year 2015, after a lapse of 14 years, my lord. That is the reason cited in the impugned endorsement, my lord, which was challenged in the writ petition. So there is a delay of 14 years, after which he comes, my lord. Much after all the 3 sons have got the compensation here. Therefore, the rejection is on that ground.
He comes after 23 years.
14 years of delay, my lord. 2001 is the scheme. The writ petitioner makes an application to the deputy commissioner in the year 2015, my lord. So there's a delay of 14 years after this scheme was implemented. And then he makes much after all his 3 sons got the benefit under the scheme.
will consider.
One reply to my lord, the objections filed by the state is concerned, and I have filed the reply, rejoinder, my lord. Kindly consider at page 177. I have given my reply to the response. At page, para 3, page number 177, my lord. There I have mentioned that page para 2, I say that my father has 4 sons, KT Manjunath, Chandru alias Chandrasekhar, KT Venkatesh, KT Krishnamurthy, myself, and 2 daughters, Jayam and Ramamani. Both daughters got married 25 years and they are residing in their marital houses with their husbands and children. I say that by the time I attained the majority, 3 of my elder brothers, namely KT Manjunath, KT Chandru alias Chandrasekhar, KT Venkatesh, had already left my father's house and had set up their own different residential houses, and they were staying along with their families in their respective houses. In my father's house, it was only my father, petitioner, my mother, Lingamma, and myself were residing. Copy of the annexure R2, ration card produced by the respondent shows my age 15, my father's age 58 years. Further, it also shows that few names are rounded off. Initially, their names were found, and after they moved to the different houses, their names were removed. Now the ration card contains only my parents' name and name, as I am residing separately with my wife and 2 children. And para 8, my lord, so but the disparity, my lord, discrimination. The contention of the respondent that all the siblings and children should be considered as one family is a new contention lodged by the respondent just to defeat the claim of the petitioner. The respondents have always considered all members residing in one house as one family and always considered the person residing in different houses as different families. Earlier, certain similar displaced persons had approached this honorable court seeking for allotment of sites. Said series of cases came to be disposed of as per the judgment dated 30/11/2015 in writ petition number so and so. Taking on the record the memo filed by the government allotting 1 acre of land each to the petitioners in Sudugavani village. My lord, one illustration is at annexure L, page 180, my lord. The order passed by this honorable court. At page 184, the petitioner is Channappa Gowda, son of Putte Gowda. Another petitioner is Shri Huvappa Gowda, son of very same Putte Gowda. And third petitioner is Shri Chandre Gowda, son of very same Putte Gowda. And the state has filed the memo while disposing of the said writ petition. May I read, my lord? Recording the submission of the learned additional government advocate and taking on the record the memo dated 19/11/2015, enclosing a copy of the order dated 12/8/2015 of the state government, allotting 1 acre of land each to the petitioners in Sugadavani village from out of large extent of land in survey number 350 classified as Gomad. These petitions are accordingly disposed of. But my humble submission is, so far the siblings or parents doesn't make any difference, so far the grant of benefit under the rebuild. Only factual issue is required to be reconsidered, my lord. Much.
8th of April for orders.
Serial number.
Where is the order? Page
Your Lordship,
120
page number 119, Your Lordship.
123. Notice returnable on
Page.
9th of June.
Appeal has been filed and notice has been ordered by this honorable court.
When it is
Connected
coming?
with, appeal number.
To be
Appeal number 1700 of 20.
notice returnable to be listed with returnable number
1700 of 24.
1700 of 25. 4. When it is coming?
It's coming up on 16th of June.
16th of June.
Please.
For the complainant, my lords.
Notice returnable on 9th of June.
My lord, I appear for the complaint.
9th of June. Notice.
Right. I appear for the complainant. my lord.
The accused may not. And also, there is a writ appeal which is pending by, the number is 1293 of 24, my lords. There's a writ appeal pending, 1293 of 24, my lord.
Writ
It may
appeal
be
is-
tagged along for BDA, my lords.
Not against this order, my lord. There is another order passed by this honorable court and connected.
You have submitted your documents?
Yes, in fact, my lord, before the learned single judge, my lord, I have produced the document CAD from 1959. My lord, this site was allotted by the corporation only, my lord. In fact, 1905 and 1959 is the first sale, my lord.
In respect of the directions contained in paragraph 4 of the order of learned single judge dated 21st June 24, which are the subject matter of alleged non-compliance, it was submitted by learned advocate for the petitioner, Mr. So and so that the petitioner has produced relevant documents as observed by learned single judge. However, the respondents have not so far proceeded to sanction the plan in accordance with law. Full stop. It is to be noticed from the directions that no time limit is prescribed by learned single judge for the respondent to proceed about the sanctioning of plan in accordance with law. Full stop. In that view paragraph, it is not possible to conclude at this stage that any contempt, much less willful contempt, is committed by any of the respondents. Full stop. The petitioner has not communicated to the respondents setting out the time limit for compliance. In the circumstances, while this contempt petition is not entertained, it is disposed of by observing that the competent authority of the respondents shall proceed to comply with the directions of learned single judge to sanction the plan in accordance with law, as per law, as may be mandated in law, provided the petitioner has complied with all the requirements, within 14 weeks from today.
Please.
Number 6, my lord, the impugned order is at page number 23, my lord, annexure A. This is in regard to a writ petition that was filed challenging a surface order, my lords. The complainant has paid the full amounts that was asked to pay, but they have not returned the title deeds as were passed in the order, my lords.
This the contempt petition relates to alleged non-compliance of the directions of learned single judge passed on 22nd August 24 while disposing of the writ petition. It is observed paragraph that petitioner having deposited the entire loan amount and having been handed over the physical possession of the secured asset, the petition is rendered infructuous. However, it is further stated that the bank and observed that the bank is under obligation to return all the mortgage title deeds to the petitioner. Full stop. Though the observation is made about the obligation of the bank as above, no time limit is indicated by learned single judge for discharge of the said obligation to return the mortgage title deeds. In these circumstances, it cannot be said that same as earlier. Within 14 weeks, within 8 weeks.
Number 7.
My lord, I appear for the complaint. 7, 8, 9, my lord, they go together. There is a common order regarding consideration of the representation. My lord.
Notice written, 9th June.
8, 9.
8-9 same.
Yes, same.
8-9 also same. Notice it.
Number 10. Petition PA. I appear for the petitioner, my lord. The grievance of the petitioner is that the third respondent, my lord, sir, is an NGO registered under the my lord, sir, Societies Act, and the institution, my lord, is aided institution by the government of Karnataka Education Department, my lord. As per Annexure E, my lord, sir, there was a post, my lord, sir, it has been filled. Annexure E, my lord, sir, is the order. Page number 39, my lord, sir. There is no sanction post, my lords, and there is no, my lords, rules has been followed. Without the permission of the government, my lords, and without the permission of the, my lords, higher authorities. 31 has been, my lords, appointed in the various cadres, my lords, SDA, FD, and higher level post. In this regard, my lords, the petitioner here has given a representation at Annexure A, my lord, page number 18.
What is HRMSI? HRMSI is what? Abbreviation of what?
There is a guideline, my lords, under the Bharat Scouts and Guides.
What is the full form HRMSI? At page, your own representative. You are Anil Kumar.
Annexure A, my lords,
What is HR? You are not drafted, somebody else drafted? HRMSI, what is HRMSI?
That without any prior approval or get sanction post, the Bharat BSGM, the Bharat Scouts and Guides appointed many persons and included them in.
Mr. Council, answer, what is HRMS? Including the HRMS without public notification. What is HRMS? You come with that full
That's
on 4th.
please. Number 11. Mr. Jayant Ramchandra, it.
What is that? None is present for the petitioner, stand out to 17th April.
Number 12.
12, 13, 15, 16, there are 4 matters. The petitioner's quarrying license has been suspended on representation made by certain residents saying that their quarrying operations are affecting their crops and water level, etc. Pursuant to which some inspection has been carried out and report has been submitted asking us to comply with certain defects, which I am instructed now they have complied with.
Not
We have complied with, except we have complied with, subject to what my learned friend will say. But primarily, the first 2 petitions, within mining, the quarrying license has been suspended, is without affording an opportunity to us. But if the learned government advocate feels it appropriate that an opportunity will be given, not keeping open all contentions, we'll go back.
My lord, may I make one submission? My lord, if this order impugned in the writ petition, which is dated 1/2/2025, passed under Rule 8K2, my lord, were to be treated as a show cause notice, my lord, and the report that has been received, my lord, by the senior geologist, my lord, that will be provided for. My lord, and my lord, if the petitioners were to produce, my lord, the compliance of the deficiencies that they were found with.
Where is the demand note? Where is that?
Annex F, page 84.
F.
84, 84.
Question at 82.
84.
84 is English. word.
84 is the operative portion of the.
Yes.
My lord, and my lord, they are giving an opportunity of hearing to the complainant, my lord, to the petitioners. My lord, an order could be passed if my lord could fix some time period.
Correct. Now report has come. If my lords are to see, this order was passed. This order at page 84 was passed.
Give a copy to them.
450 with petition number.
Yeah, give it, give it. Lord, I'll file a memo to that effect.
They have closed the,
Suspended the acquiring operations.
suspended with immediate effect.
Yeah, immediate effect notes, awaiting if the previous page, if lordships are
So
to
the
see.
report was called for by order dated 18/3/25.
Yes, ma'am. Now the reports have come, my lords.
Where is that report?
Well, Lord, along with the memo I have filed,
Over the report memo. Government.
well, Lord, the report from the director,
What does it say
Directorate General of Mine Safety.
against them?
No, it is in compliance.
So they want,
Remedial measures, my lord.
My lord, some points are correct, my lord, some of the.
so their
Complaint
report
point
suggests
is
some
correct.
remedial measure.
Yes, my lord. At page 23, they have suggested certain recommendations for us to carry out. 24, my lords, is this. Yeah, this is.
The town. What is this lake of the town?
ನಮ್ಮ ಡೈರೆಕ್ಷನ್ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲಿದೆ.
So we'll say that this order will be treated as notice.
Yes, and.
You will hear the petitioner.
Yes,
This copy of the report which is supplied to the petitioner, which will
Yes.
be entitled to submit to you that the compliance is
Please.
remedial measures are taken. You will verify.
Please.
You will verify that and pass.
Please.
approval.
my lord, may I make one submission? My lord, since this was based on the complaint given by a person, my lord, if we could issue notice to him also.
All, it may be
Yes,
Very well,
just to
let
give
them,
a notice to
complainant
the
also issue notice.
intentions.
Okay, let them,
Then there is no difficulty.
they have to.
But where is that?
My lords may take page 84, my lord. That is the order impugned before your lords. Yeah.
So all means only complainant.
Only the complainant, not the other
Complete-
persons.
My lord, no, only the complainant.
No
on-
public. Yes. So we'll pass that order within what time?
My lord, I
I put it
seek for 8 weeks' time because considering that there are.
4 weeks. ma'am.
No, I leave it to my lord because.
4 weeks from the date of receipt of the order.
Please.
So the order
Here.
will be available on second
Very well.
copy.
Very well. Lord, these are first,
Make it clear.
please, these are not first two matters, Lord. The other two matters, my lords, where in respect of the same quarrying, the crushing license has been suspended.
My lord, similar matter
No,
repeated.
no, otherly, there is no authority. But the 15 and 16, serial number 15 and 16.
This was serial number 13.
12 and 13.
So both are same.
Both are same, respect of different survey numbers. In so far as 15 and 16 are concerned, 15.
My lord, in those I am filing a memo.
बंद
Madam, madam.
Dispose of
Public notice for the one come from participant.
this I give to this number. So 13 is same.
No, whoever is that. Plain non-tenth.
Where is 30?
Complaint put out. We can't say only when we get when it comes to on behalf of everybody, one person. Yes, yes. Yes.
Gonna be one more.
In these matters, the authorities must take into consideration the reports already submitted, Lordship. May say one sentence. They already submitted certain reports, which shows compliance.
That will record it according to you, but still they will verify.
Very well, very well.
We'll say that the report, as per the report, the remedial measure taken petitioner.
Please, please.
Which will be verified by you.
Yes, my lord.
Please.
And if further remedy is required, you will come.
Very well.
Yes.
In so
Now-
15 and 16 are concerned, same thing, except they have exercised the power under the stone crushers license order for the purpose of suspending the crushing license, because we use a crushing machine in respect. There, my lords, our contention is it is without the authority, because it has been done by the member secretary, whereas the section requires that the district level committee has to do it. But same order could be passed subject to one rider. The order may have to be quashed as being without jurisdiction, and liberty granted to them that if they propose to do so, they can do it afresh.
My lord, paragraph 8 and 9 of my
Here there is
memo.
no report.
There is also, no, there is no report. There is no report. Here there is a suspension of stone crushing under the stone crushing license order.
Report, here also it is directed.
My lord, there is a report, my lord, which is dated 20th February 2025.
It is already
But-
filed.
Yes, yes, as annexure R3. And I have said all this will be placed before the, my lord, the stone crushers licensing authority, my
Yes,
lord,
but the
committee.
impugned order is by the executive member who does not have the authority at page 42. That is the
That is
primary
being
contention.
considered as a show cause notice.
And
And
There
this will
cannot be a show cause notice by an authority without jurisdiction. There the executive member. It has to be show cause notice has to be by the authority concerned.
Where is show cause notice?
No, page 40.
My lord, this contention can be taken so that a quietus can be given in future, my lord, and that, my lord, the senior geologist cannot invoke, my lord, such a jurisdiction and then pass an order. If this contention were to be urged by the petitioners, my lord, that will be decided by the committee and an order, my lord, and observation
Hearing-
can be
In
made.
the earlier matters, hearing will be given by whom?
By
By the
senior
district level
geologist,
committee.
because it is a quarry lease and license.
By the district level committee. No,
Don't make a look, बंद करो.
other than
Don't waste time.
the section procedure.
My lord, 12 pertains to quarrying license, 13 pertains to quarry lease.
So here also district level committee will give hearing.
No, the senior geologist gives a hearing here in 12 and 13.
So that is what we are asking. To 12 and 13, who will give?
Senior geologist.
The,
That is
the
correct.
authority
That's
who has issued pass the order.
correct, correct. That is correct.
Or here, who will
15
do
and
the hearing
16.
if it is-
My lord, here this will be placed before the Stone Crushers Committee, my lord, and they will take an action because, my lord, the order could not have been passed by the authority concerned.
As
Since he
per
was a
section
member
11.
secretary. But this contention can be taken by the petitioners with regard to that, and then, my lord, a finding can be given to that effect.
No, but the impugned order has to go, my lord. It has been issued by an authority.
My lord. So that in future, my lord, such notices cannot be issued by these
Where is-
member
where is that
secretaries.
Page 42 is the operative portion. It starts from page 14. At page
So
40,
according to you, a member has no.
he does not have the jurisdiction under section 11. Section 11. Licensing authority has been defined. Section 11 read along with section 8. Licensing authority has been defined under section 8. Section 11. Read with section 8.
So he is not a licensing.
He is not in the license. Licensing authority has been defined under section 8.
So here geologist is not a member.
He is only a member secretary. He is only a member secretary. He cannot issue a notice without the authority of the all other members of the place.
No, it is not done.
He cannot issue. Lord.
No, it is not done.
It is not done. No, he has done it by himself.
Yes, my lord. So that
it
is the reason why I said,
Then
my
expressive without jurisdiction.
Yes, without jurisdiction.
my lord, but there were some violations.
That's all right.
My
But,
lord,
So
no, let me make my submission. There
Very-
are some violations
here
which
very-
the member secretary will look into and then place it before the committee, my lord.
No, here where is the order?
that
No
is
order, my lord, this is a
no, he has
notice.
suspended it at page 41. He
Under a notice, he suspended. 31,
Same.
1,
page 41,
2025.
Lords, yes, page 41, Lords.
Same notice 31/125.
Yes.
Yes.
Now, any report is issued pursuant to the order of this court.
My lord, there is a report that has been issued.
Where
My
is
lord, along with the memo I have filed.
Same thing, Lord, which they refer to the earlier one. 12:30.
Same
report.
Same report.
Same thing, same incident, same issue.
So we just
Make
want to
this
give
open.
it the quietus by giving a hearing to all
So
the
Here,
parties.
here there will be one additional thing. That, but in all this, then order will have to go.
My lord?
When other will treat the order as notice.
Yes,
Here
yes,
this-
yes.
Here,
my
this
lord.
order has to go without
Here
jurisdiction.
this notice will go
Hmm.
Liberty with
in
the,
view of the contention that it is
Without
not within the jurisdiction of the issuing authority in view of section 11 read with section 8, and the committee shall examine within 6 weeks or 4 weeks.
yes, that should be.
Correct.
That there, please. If
My lord,
this,
my suggestion
Same
was
thing.
they could have given a reply saying that the person who has issued it has no jurisdiction.
why should we
to
go
do
and
that.
submit ourselves before an authority?
It is for the committee to decide.
Where,
Yes,
my
and
lord, the committee will decide. Once the objections is filed, my lord, for the notice, and my lord, everything is heard, it will be placed before the committee.
We'll say that setting aside of the order by the court will not mean that we have,
Very well.
Will not preclude the committee from initiating proceedings if this.
Obliged, my lord.
will not preclude.
It will not preclude. That should be,
That is fair enough.
section 11,
Leave it to my lord.
in accordance with section 11.
If it found that.
If it feels it necessary.
We'll do that.
But there's only one request, my lord, which is really not part of this. But they have already, prior to this suspension, for about 40,000 tons, for about 40. But prior to this suspension, about 40,000 tons stone crushing they have done. It is lying by the side. They have to transport it. That's all. There is after take. Huh? Lordships may permit us to transport it without, I don't think there should be. But prior to suspension.
That prayer also may be made
Very.
Obliged, my
to
lord.
the committee.
Please.
This is 15 also disposed of. That line, shall we?
But this also 4 weeks, not let them.
4 weeks from the date of receipt of the order.
In case they propose to do so.
So what about the other matters?
No, they are all over, my lord. 15, 16. 12, 13, 15 and 16. 14 is a different matter.
Same within the two. And I said the proceeding shall be concluded after giving the opportunity. We'll further, we are inclined to further direct that if you are inclined to start press proceedings, we will do within same 4 weeks.
Very.
Conclude within further 6 weeks.
Please.
After hearing both.
Please.
Obliged, my lord.
16 also same?
Yes, my lord. 16 and, no, 15 and 16 are same.
14 is different. 12, 13 and 15, 16.
14 is not ours. 14 is not part of our.
16 is same?
Yes, 15, 16 are this
15,
stone.
16 same. 15 is साथ में रख like. That's
Please.
It's number 14 to my address.
I appeal for the petition. Serial number 14, 27, 28 are similar matters that may be tagged with serial number 54. In some of the matters, not interim order is granted till next date of hearing. That may be made absolute
So
My
can I
because
reply?
lord, here, my lord, we are thinking of getting it remanded back at the hands of my lord because the quantification this court observed was not very clear as to how they have quantified the penalty. My lord, I have put it across to the secretary. I haven't received any reply. My lord could have
So
it.
14, 27, 28 and 54.
Yes.
Common order. All these petitions involve common facts and similar facts and identical issue. The orders are also passed on the same lines. Full stop. Learned additional government paragraph. Advocate Srimati Nilofarakar. takes some time to take the instructions and in order to take a stand in relation to the controversy. Full stop. All the petitions will be listed on. We make it on 22nd at 2:30. So if it is to be sent back,
But,
2:30 or not?
My lord, first week, my lord, after vacation. I can
After
pursue
vacation.
it. I
After-
can pursue it, my lord.
He is happy because he is enjoying it.
My lord, but I'm
no,
not getting
even
any
otherwise,
response
that
from
there
the.
is no report at all for quantification.
All right. As requested by learned to send out to June 5th,
Obliged, my
Oh.
lord.
5th June. The petition still further on.
Obliged, my lord. But in some of the matter, my lord, we have filed a memo for dispensation of notice to, service of notice to the respondent number 5.
Who is 5?
5 is the association of these, the formal party, my lord, though it was recorded in the order. That day it was not dispensed with, my lord. The order was not asked to dispense the service of notice to respondent number 5.
You are deleting the,
I'm not in, my lord, for issuance.
no, then you delete them. You delete on that day by filing a memo at the time of hearing of the petition. Disposal of the petition, whenever, so that.
What I am requesting is the notice may be dispensed with for time being, my lord. And then
Learned advocate for the petitioner, Mr. Mahendra stated that in all petitions, respondent 5 is a party whose presence is not necessary. He requested that for the time being, notice to the state respondent 5 may be dispensed with. Full stop. Petitioner may not serve notice to respondent 5.
obliged.
Number 17.
Lords, I appear for the petition. Both serial number 17 and 18 pertains to Lords mandamus for deemed conversion. Covered by my Lord's statement.
My lord, can I take a notice and my lord may have it next week, my lord?
Covered.
Just like to intimate the deputy commissioner. A week's time.
Advocate Mr.
Sridhar, my Lords.
Sridhar.
Sridhar.
Relies on decision of this court in Sri Guru Siddhappa, Himappa, Unjigavi. Versus State of Karnataka and others. Which was writ petition number 1366 or 25, decided on 7th February 25. To submit that the facts are similar, therefore the order may be passed in the present petition on the same lines. Paragraph learned, post of notice returnable on
Third, my lord may have it on.
3rd of April. Learned additional government request will kneel over for exception notice. And 6th time to, first time up to 3rd of 6th time and learned notice returnable, full stop. Notice returnable, full stop. Learned additional government request will kneel over for 6th time to take instructions. Full stop time is granted. Put up on 3rd of April at 2:30.
Obliged.
How many to both matters?
17 and 18 both.
Both matters.
Obliged.
Obliged.
कहाँ गया? 20.
1920 are urgent. Number 21, Mati Sudadi.
21 is also urgent? No.
Due to some inconvenience, senior counsel couldn't reach in time. I'm seeking short accommodation, ma'am.
25th of April,
Much over.
as requested. Twenty-three is already adjourned, not adjourned.
22 is urgent, number 23.
For the
For
response.
the petitioners. I ready to argue the matter. I ready to argue the
Okay,
matter.
file my objections. and
Objections.
Objections also has been sent to my learned friend via email and WhatsApp.
Pardon? Your voice is not reaching.
Oh, please, my lords, I am for respondent number 1. I've already filed my statement of objections and
You want
copy
to
has
file?
been served to my learned friend, my lords.
You want to file?
No, I've already filed. My lords.
And matter is for the right of way, minimum communication of road, my lords. Minimum, public's required minimum communication of road, my lord.
Minimum
Communication of road.
communication.
State has to provide minimum communication of the road.
So,
This matter is required about the judicial review in accordance with the Article 13 of the Indian Constitution, my lords.
oh,
This repetition PIL matter is mainly about the veracity, calling and question about the in two sections, in two parts, Part A and Part B. My lord, in Part A, state must provide proper any type of communication or access the road or service road or bypass road or village connecting road or any alternative road from one place to another place. That too, while concerning the collection of toll, my lord. Part B, said challenging in a national highway road is unauthorized on the ground of the developed road and rendering services are not in accordance with the law. That will argue the matter along with the material documents, my lords. Now I argue the matter pertaining to the Part A. My lords, I have already been adduced before your lordship. This is precedent law, my lord. Kindly may come to state of Himachal Pradesh versus Umadram Sharma, para number 11, my lords. May I read, my lord? May I read, my lords? Para number 11. It appears to us that the facts in the case, the controversy lies within the short compass. It is well settled that the persons who have applied to the High Court by the letter or persons affected by the absence of the usual roads.
Where you are reading?
My lord, para number 11.
Of what?
Precedent law, my lord. Umadram Sharma, state of Himachal Pradesh versus.
Have anything you pass?
I have already adduced before your lordship, my lord.
We don't know where it is.
The citations have already been adduced.
Can't argue in first person. Where is that? We don't have it.
In the preceding dates, I have already been.
Come
So
on,
last
third.
title put it there.
Come on, 3rd. 3rd of April. At 2:30.
My lord, I give.
Live.
My lord, I already been given, my lord.
Live.
It is in the file only. In the first date, I already been given.
Which labor and this Suraj Prakash Bhandari?
No, my lord. Umadram Sharma, state of Himachal Pradesh versus Umadram Sharma.
Himachal Pradesh. Umadram Sharma,
Umadram Sharma, my lord. Please, my lord.
So what is that public expenditure for projects?
Para number 11, my lord.
Para 11.
May I read out, my lord?
Yes.
It appears to us that the facts of the case, the controversy lies within the short compass. It is well settled that the persons who have applied to the High Court by the letter are the persons affected by the absence of usable road because they are the poor Harijanas residents in the area.
Their access by communication, indeed, to life outside is obstructed and are prevented by the absence of road. The entire state of Himachal Pradesh is in hill and without workable roads. No communication is possible. Every person is entitled to life as enjoined in Article 21 of the Constitution, and in fact, of this case, read in conjunction with Article 19, Class 1, Class D of the Constitution, and in the background of Article 38(2) of the Constitution, every person has right under Article 19, Class 1, Class D to move freely throughout the territory of India. And he has also right under Article 21 to his life. And that right under Article 21 embraces not only physical extents of the life, but the quality of life. And for the residents of hill areas, access to the road is access to the life itself. My lords, further, the propositions are well settled. We accept the proposition that there should be a road for communication in reasonable conditions. Kindly may notice, my lord.
You had gone for, you with your family had pilgrimage. Go on some temple,
Reasonable conditions in view of the
This
constitutional
family
imperatives.
traveled to T. Narasimhapura to Gopal Swami temple and found that the road by NHI was not qualitative road.
My lord, there is no road at all to travel from one place to another. Article 19(1)(d) and Article 21 provides minimum road under the imperative condition under the Constitution.
Article 91 provides for road.
My lord, that will argue the matter, my lord, along with the precedent law, my lord. Covered judgment here is here.
Article 19 provides for.
Yes, my lord, please, I will provide further, my lord. Now I'm arguing the matter on.
You are saying that Article 19 provides for good roads. Let us see.
My lord, now I argue the matter on Article 21, my lords.
Then let us see about road. Anything about road in Article 20.
I will adduce, my lord. I will adduce, my lord, now.
First we see article only.
Article 21, my lord. Now I'm arguing the Article 20.
Let's see Article 21. Anything about road in this article? Read Article 20.
Article 19, my lord.
Whatever article, wherever road is referred to, you mention that article.
My lord, road is, my lord, in this precedent law, Honorable Supreme Court clearly held that providing the road is an imperative nature under the article. It is under Article 21, it is valid. That is what held by Honorable Supreme Court in this precedent law, my lord. That is what I'm just reading here. Here is clear that there should be a road for communication in a reasonable conditions in our constitutional impediments. And denial of the right would be denial of the life. As understood in its richness and fullness in the ambit of Constitution, to residents of hill areas as far as feasible and possible, society has constitutional obligation to provide roads for communication. Constitutional obligation for the provide for the communication. This is for the Article 21 and Article 19, my lord, 19 Class 1D. Now I argue the matter on Article 19.
Road is not provided to this Gopal Swami temple.
My lord,
you go there? What is this?
My lord, state must provide any alternative road to travel from one place to another place. What is Article 19(1)(d)? Freedom to move freely throughout the territory of India. Every citizens have a fundamental right to travel one place to another place. That is a fundamental right. I burden with the Article 19(1)(d), freedom is not an absolute right. Subject to condition, reasonable conditions may be imposed. But however, such reasonable conditions must be within the purview of the law and acceptable by the general public. That is what held by Honorable Supreme Court in the case of NB Karre versus State of NB State of Delhi, my lords. Kindly may come to para number 21, my lord.
Which judgment? Which judgment? Umaid Ram Sharma.
No, my lord. This is second judgment. Now I'm talking about now first judgment, my lord.
So first
NB Karre versus State of Delhi. Para number 21, my lord.
My lord's voice is not audible, my lords. Just wanted to bring it to my lord's notice.
21 para number. May I read, my lord?
Very good.
NB Kare versus State of Delhi, para number 21, my lord. Adu sa kottidini. Thus, the primary question which requires consideration is whether the imputed legislation which apparently seems to be in conflict with fundamental right enacted in Article 19, Class 1, Class D of the Constitution is protected Class 5 of the article, under which a law would be valid if imposes reasonable conditions on the exercise of the right in the interest of general public. Kindly may notice, my lord. Here clearly stated that impose reasonable conditions on the exercise of the right in the interest of general public. Further, it is not disputed the question of reasonableness is the justifiable matter which has to be determined by the court. If the court holds that the restrictions imposed by the law to be reasonable, the petitioner would certainly have no remedy. I will come to the part of reasonableness in detail, my lord. Further, if on the other hand, they are held to be unreasonable under Article 13, Class 1 of the Constitution, imposes a duty upon the court to pronounce the law to be invalid to the extent that it is inconsistent with the fundamental right guaranteed under Part 3 of the Constitution. Now I come to, for a moment, I come to the Article 13, Class 1, my lord, 13 and 1. Article 13, law inconsistent with or in derogation of fundamental rights, subclass 1. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provision of this span, shall, to extent of such inconsistency, be void. And also further, subclass 2, my lords, the state shall not make any law which takes away or abridges the rights confirmed by the part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. My lord, in this matter, what is the reasonable condition in this subject petition here is, number one, so reasonable condition is pay the toll fee and use the road, number one condition. Number two condition here is, my lord, by unauthorized putting the unauthorized toll plaza and unauthorized development of road and servicing unauthorized not in accordance with law, this is the reasonable, this is the restrictions invoked in this subject petition, my lord. Now, the Article 19 1D and Article 21 is one side and the restrictions are in another side. The restrictions are overtaking the mother law of the Constitution is under Article 21 and 19 1D, my lord. It would not meet the purport and intention of the Article 19, Class 1D and Article 21. It is a free movement. Anyone, citizen, anyone can travel from one place to another. It is a fundamental right. Hence, the reasonable conditions not sustainable because of the overtaking the mother law of constitutional law, my lord. This is one. Now, the Honorable Court may be take judicial notice in this matter, my lord, keeping the view of the Article 19, Class 1D, Article 21, and Article 13. Keeping the view of this, kindly may notice, at the time of purchasing any vehicle, every publics are paying the tax in the head of road tax. Hence, the state's imperative duty to provide the minimum road of communication from one place to another place, my lord. This is number one. Number two, some of the vehicles are prohibited in the National Highway Road, such are tractors, animal vehicles, cycle, auto rickshaw, those are. But inevitably, because there is no alternative road, they have to travel in the National Highway Road. It would clearly amounting to the doctrine of injurious in them, legal injury without damage. Now, ಉದಾಹರಣೆಗೆ ಹೇಳೋದಾದ್ರೆ ನಾನು ಪೇಮೆಂಟ್ ಮಾಡಿ ನ್ಯಾಷನಲ್ ಹೈವೇ ರೋಡ್ ಅಲ್ಲಿ ಟ್ರಾವೆಲ್ ಮಾಡ್ತಾ ಇರ್ತೀನಿ. The number of, for an example, the number of persons 100 paid members. If non-paid members are 50, the total number of persons are traveling the road is 150. While I'm making a payment of fee and traveling, I have a duty upon drive the vehicle upon 100 vehicles, if non-paid members also included in the inclusive in the national highway road, I have a duty increases. This would amounting to the injurious in damage, legal injury without damage, my lords. And in the substantive law, one of the substantive law, the Indian Easement Act 1882 clear states that minimum road should be given. My lord, I have one property here, a private property. Another individual property is there, far away from my property. I have to go across by another individual property. Hence, this Indian Easement Act may would applicable. The minimum road should be given. In the same scenario will be applicable in the subject petition. The state has acquired entire land and giving the unreasonable restriction stating that pay the toll fee and use the land. How can it be possible, my lord?
Only 5 minutes to argue now. You can complete within 5 minutes.
The infringement of right may be affects the one person only, madam, in a normal scenario. While we consider in a vehicles, the number of persons, passengers might be infringing while we traveling in the said national highway road. And now I come to the part 2, my lord. So challenging road is unauthorized on the ground that the developed road and rendering service is not in accordance of law. My lord, I have adduced before your lordship about the road standards and specifications manual, my lord. In the 2-laning of highway, 4-laning of highway, and 6-laning of highway. In each road specifications, I have mentioned the provision of the service road, how to develop the road. This may be one thing. This may be considered as a one of the thing we could consider it as irrefutable presumption, my lord. What is that means? There should be prevailing nature of service road in particular situations. The intent of the legislature mind to provide the right of way to the public. If there is no way of alternative road, the service road should be prevailed. In that situation, service road may be prevail, my lord. In this matter, service road or alternative road or village connecting, there is no road. It is normally a village connecting road, but in garb of putting the National Highway Toll Plaza, they are claiming it as authorized National Highway Road, which is not acceptable in the eye of law and jurisprudence of law.
Yes, madam.
And my lord, I have I require to make submission CD, my lord. I have recorded the road video. This is a part of the petition. I have made it as an annexure. Kindly my perusal in the open court. Most of the videos all are 20 seconds, my lords.
Not
This is a
not permitted. Yes.
my lord. Kindly may accept, my lord.
No CD we are not permitted.
My lord, photos are be here.
Okay, whatever pleading you want to give. Yes. Who is for National Highway Authority? Yes. What do you say?
Yes, my lord. I am for the respondent number 1, my lords. I am representing the project implementation unit of that particular area, which is a wing of this National Highway Authority of India, my lords. So for a moment, I will just request this honorable court to peruse the prayers made in the petition.
We'll continue on 8th.
Please, my lords, as convenient to this honorable
My lord,
court.
pardon, my lord.
We'll continue the hearing on 8th.
Next day, please.
8:30.
My lords, 8th, I have some difficulty.
Meantime,
May I request for 9th or 10th, my lords?
7th.
Grateful, my
meantime, I
lords.
pass interim order.
7th. Because
Grateful.
you appear to be, your argument appears to be longer than the petition.
No, my lords, it's just only a kind of an, it's
The way you
so
started.
basically, my lords, my argument is only on the legal basis. Whether the contention of the petitioners is the toll that has been levied.
Mr. Counsel, you
is
must know your
unjust.
matter. You must know your defense and you must know your judge. Otherwise, we will know discipline over time. So 7th at
Very well said, my lords. Please, my lords, grateful.
7th you argue at 2:30. Yeah.
Oblige, my lord.
There should be a service road. So that you can enter the users can.
Yeah. Government circular to go.
So you made a lot of efforts in investigating.
In fact, he was in fact, my lord, asking if he did something wrong. I said, if you had
No,
done
nothing,
something
sir,
wrong, my
nothing.
lord should have certainly stopped you.
Nothing.
You made a best effort. Is
Be,
what, my lord, I
be
said.
little more focused. Rather than general arguments, you focus. Focus on the niceties. General principles everybody know. 21, 19, good roads, quality of light, but you focus.
Also,
You focus will consider on 18.
there are the substantive law. They have to act according to the substantive law, but they are not in accordance with the law. I have a proof. I will make submission in the next date, my lord. Much obliged.
Seal number 24.
Ma'am, I have sought for certain reliefs, my lord, as the government, my lord, which has its basis. May I just
Order dated 9/12/2024, passed by my lords. That would be 9/12.
I don't know. In fact, my lord, my learned friend appears to be, my lord, representing. I don't know, my lord, it's a government or, my lord, if they are impleading in the matter, my lord, let him come after the.
Should be knowing. That's I appear for respondent number 3, but that's just for clarification of the petitioner.
He appeared last time.
In fact, my lord, there is no way, my lord, we are deviating from this. The petition, my lord, the petition hinges on a very, my lord, minor issue. If your lordships could kindly have, my lord, page number 335, there are page number, my lord, 230 for a moment. This is all, my lord, the confusion is. My lord, I can't say that I will not pay because, my lord, I am now bound by the orders of the court. There is no way, my lord, I can say I will not pay. Page number 230, my lord, item number 8, under the general directions, my lord, the direction to me is to the amount of environmental compensation will be deposited prior to the issuance of amended environmental clearance. I'll have to deposit this prior to the issuance of amended environmental clearance. I have applied for amended environmental clearance, which has not been issued.
Where did you read?
My lord, at page number 230, my lord, the general directions of, my lord, the NGT. NGT, my lord, issued 2 sets of directions, the specific directions, which my lord should kindly get on page number 227. Then, my lord, the general directions.
Environment complaints will be deposited prior to.
I have been mulcted with a fine of about 117 crores, which I have no defense than to, my lord, deposit.
my lord, which I have undertaken before your lordships, my lord. Now, the issue is, my lord, on page number 230, the item number 8, the last item, my lord. The order reads without any ambiguity, page number 230, my lord. My lord, item number 8, the amount of environmental compensation will be deposited prior to the issuance of amended environmental clearance. My lord, this amended environmental clearance has to be issued to me, upon which I'll have to. My lord, after the NGT, my lord, we have applied. And my lord, they rose certain queries. You have to produce several things, my lord, we have satisfied all that. And my lord, on the part of the government and the departments, my lord, there are certain things to be clarified, that they have to identify the Karab, etc. And my lord, till today, the amended environmental clearance has not been issued. The earlier one which was issued has already been cancelled. Unless they do this, my lord, I can't, my lord, say that I'll not pay, nor I have a right to, my lord, decline from the order. Only thing is, my lord, now when I ask for the amended environmental clearance certificate, they would say, my lord, they wouldn't even say anything on that. My lord, if they say that within which date, my lord, they'll issue me an environmental clearance certificate, my lord, I don't mind depositing, my lord, which is what I have undertaken.
Let's make the submission. That same submission, my lords, made on the first day of hearing, subsequent to which my lords had recorded. Let them come on 9/12. Paragraph number 5. Learned senior advocate, my lords, on 9/12.
They rely on the same calculation and issue proposed notice.
Last paragraph number 5, my lords. Learned senior advocate for the petitioner submits that if the requirement of applying afresh for amended environmental clearance is not to be insisted upon, the petitioner is ready to deposit the amount of rupees 117.35 crores, which was assessed by National Green Tribunal towards environmental compensation. My lords, the clause which the senior even read out, my lords, at page number 230, point number 8. They have to first come and deposit that money, my lords, before even starting the process. It's like paying the fee before we even enter an admission process. Now, my lords, they are coming and saying that, okay, first tell us when and where you're going to give it to us, and then we'll pay. My lords, that is not the way the structure would work. Respectfully, my lords.
My lord, my learned friend, let him, my lord, instead, my lord, saying all these things, place, my lord, a statement of objection briefly whatsoever. My lords may kindly hear us on 7th, my lord, so that with the pleadings in hand, my lord, we'll be able to deal with the matter. My lord, today they can't introduce, my lord, this new dimension to the order of the NGT, which is not even the NGT's order.
A matter which has gone up to the Supreme Court attained finality with regard to the every word of NGT. That's today is being re-agitated. That's in fact the interim order was to stay the demand of 117 crores, which of course they didn't press for it.
No, the environment clearance is to be issued by you.
Environment clearance should be issued by SIA, that is state level, which my friend would be representing. The compensation has to be coming to KSPCB as a matter of.
So any Mr.
Sir,
Any hitch or any difficulty in issuing the certificate?
I want some time to take this. Because we have to kindly the direction not fresh. The matter has to look into a fresh after. We are required to consider other materials also. Kindly see, I will read that.
So that is exactly we are asking. Any difficulty or any impediment, any hitch?
I take some instruction next week.
If I may make one submission, I appear for the impleading applicant. On a question of law, my lords, I appear before the NGT as the executing applicant to execute this order. On a question of law, my lords will also have to decide whether a valid EC survives, because under the 2006 EIA notification, there are time limits, my lords, for the validity of the EC under clause 8 thereof. The EC has lapsed, my lords, and therefore the entire procedure will have to start afresh. I appear for a civil society organization.
Applying afresh, that is the what contemplated, applying afresh.
There is nothing, my lord, of that sort. My lord, they are insisting for that. The one which was cancelled, my lord, now, my lord, our precise grievance before your lordships is that they are asking us to do afresh, my lord, which is not the purport of the order.
The EIA notification in my humble submission mandates that application, my lords. That is the position I urge.
We will go by the judgment of the NGT, my lord, which has travelled up to the Supreme Court, and my lord, which has attained its finality. Let there not be, my lord, introduction of new things now, my lord, in the order. Lord, my learned friends can't be reading something, my lord, which is not there in the order. Let them comply with this, my lord.
if my impleading may be allowed, my lords, I'll place this material on records. I appear before the NGT and there are parallel proceedings, my lords. I am also the original, one of the original complainants and the executing applicant currently, my lords.
When 10 this time.
I 10 days.
Next week, anything.
We'll give 10, we'll give 10 days.
Anything.
9th.
Any 9. Within which let my learned friend, my lord, keep some the statement of objection whatsoever, my lord, so that, my lord, we don't talk in the peripheries, my lord, we are.
So his 10 might be decisive.
Yes, he is the main person, my lord, who has to, my lord, respond to me. My learned friend, case, PCB and the impleading applicants, I don't know, my lord, they can improve the case which has already reached its final issue. They can't.
We are not improving anything, my lords. Let there be no such submissions. We are just clarifying the order, my lords.
Improve in the sense that if the stand of your learned friend is in favor of the petitioner, then your argument will
Yes,
not serve.
that's for which, please, my lords, we will
It
make
appears
us.
prima
Yes,
facie.
yes.
Yeah.
Sorry, right.
So when?
And any days next week.
This is for what? Some query.
There was a huge, my lord, development. My lord, the allegation of a public interest litigant was that we have violated, my lord, environmental norms, etc. And my lord, the Honorable NGT took up the issue. Mulcted a fine on us. We were mulcted with a fine, my lord. We tried till the Honorable Supreme Court, my lord.
What
Today,
is this? What is ACIAA?
state level, my lord,
State
environmental clearance.
Assessment authority.
In fact, assessment authority.
So it is entire your stand which is.
That's all, my lord, that's all. Lord, there is no dispute on the liability. Liability is, my lord, settled. No
So
way, my lord, I can dispute the
You have to apply your mind in respect of the general conditions, all the general conditions imposed by the NGT.
Yes.
Yes. Any day, my lord. Next week, any day.
Tell your date will.
9th onwards.
Whenever you want.
Second week, April. April 2nd week.
April 2nd?
Second
No.
week.
Give week up.
Second week, my lord.
Second week. 15th?
Please.
15th.
So great.
Yes.
Thank you.
That's what meant to reach its, knowing that you, the GTS gives the direction saying that. They should direct the review, not submit to revise it, revise. That should be considered. Issue, but enforcement.
So there is no communication between that authority and assessment impact authority and you, there is no correspondence.
A lot of correspondence and communication.
After NGT order.
Yes, we have repeatedly been requesting. My lord, in fact, earlier, my lord, environmental clearance certificate was cancelled, which we challenged. The NGT said no, the cancellation is incorrect. Then, my lord, now they'll have to, my lord, reissue the same to us. Now, my lord, they're asking us to apply afresh, my lord. To apply it afresh, my lord, it's a big travel, my lord. I'll have to take at least as many as 20 different NOCs. That distress I can't be put to, my lord. That distance I can't be put to again, my lord. I'll have to go travel my journey once again from, my lord, point A, which is impossible. And the NGT on our repeated applications precisely said that no, the cancellation was incorrect. It was held to be wrong.
You are,
I am for the impleading applicant, my lords.
who are,
The original complainant before the NGT and the current, if I may
They
be.
have achieved their job, my lords. I have an appreciation for them. They have achieved their job. And, my lord, it's because of their efforts, my lord, I have been marked with a fine of 170, my lord, which I have to do to the state, my lord. There is nothing, my lord, no second thing. But I really appreciate their work, my lord. Let them not improve it here.
May I, my lords, may I make just one submission? May I be permitted to file a very limited reply on just one aspect on the validity of the EC?
how many achievements you know want?
My lords, this project is the cause of Bellandur
Will-
Lake flooding, my lords.
We'll consider on that.
If I may be permitted to file a very short reply, my lords.
File.
I'm deeply obliged.
You're a party,
Please, my lords.
you're a party.
I'm an impleading applicant. My application has not been allowed. If the court is so kind to allow that app,
Makes oral submission.
please, my lord. So very.
So great.
Yes, number 30, Darwin V. Chavan.
Not there.
Darwin V. Chavan. 30.
Go on then.
Seek short accommodation.
It will go to any urgency. 16th of June.
Number 31, AMC Basuraj.
Nobody is there. 10/2, 17 June. Since none is present.
This is number 32, Rajeshwar PN.
Only appear for the respondent number 4.
My lords, may I make this submission on behalf of the state, my lords?
Final hearing.
We need to file objections, my lord. State needs to file objections, my lord.
You want to file objection?
Yes, my lord. In the order also, it's observed as such, my
Appeal
lord.
what? Reply you want to do? Reply must have been filed in the
Reply, we have not yet filed, my lords. We have almost finalized it. We need some accommodation to
In
file.
any case, will not take up today. So when will?
Any date your lordships find convenient.
My lords, first week of June, if my lordships were, please.
10/2.
The agencies, my lords, they are again coming and disturbing, my lords, allowing third.
Have you granted the relief?
Order of status quo is operative, my
These are
lord.
all false because there is an order of status quo. We could not have interfered.
When I go and complain to the police said, let the revenue authority say we'll take action.
No, this is
Therefore, I
all
request
false.
The government, my lords, to instruct the police that third parties do not. come.
Your remedies if the committee breach is coming.
My lordship's order is operative, my lords.
Yes, my lord.
At
One
the request
request,
of,
Nobody
my
would
lords.
dare to do this. This is
at the
a-
request of learned additional government advocate, Mr. Navin Chandrasekhar, who wants to file reply.
Very much, my lord.
Comma 10/2, which 10th of June,
Very much, my lord.
10th of June,
4th April.
4th April, 4th April.
Yes.
He wants first week of June.
First week of June. First week of.
Very well.
Agency is for us. For them, there is no urgency. For us, they are urgency.
You are enjoying relief?
He's enjoying it.
10th of June.
Very much, my lord.
Interim order may kindly be.
Is it limited? It is not limited. Not limited.
Not limited. Great.
Interim relief shall continue to operate
Great.
till the next date.
Yes.
Yes. Number 33, Mr. G.S. Venkat Subra.
Pardon? What is saying?
Passover.
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 Passover is not possible today. What is that? Some law license, bar and restaurant.
That's it.
10 to 5th of June.
Intermediate extent. Intermediate extent.
There is no interim leave.
Intermediate there.
Interim leave shall continue over till the next.
Much of them.
Number 34.
That's appear for the complainant, my lords. The compliance affidavit is filed, but actually whether the amount is transferred or not, I couldn't get the information from the complainant since he's 80 plus, my lords, he was hailing. I couldn't get him over the phone. Request for a week's accommodation.
Stand out to 8th of April to be listed at 2:30 in view that learned advocate for the petitioner wants to verify about the actual deposit of the amount.
On the previous date, you had asked us to produce the orders. These are the, this is a contempt arising out of the non-compliance of the RERA orders. So we had not produced the same, we're producing the same now.
This is the same matter.
My lords, what's happened is the Tahsildar is the executing authority, my lords. So when the Tahsildar verifies where the location of the properties are situated, under the Tahsildar who's made a party before the writ court, it doesn't come. Only the registered office is situated in the jurisdiction of the Tahsildar. That is also a leased premises. So we were able to find it out with the Inspector General of Stamps that all of the properties are situated in the jurisdiction of Devnalli. So now they have to get a modified order to make the Tahsildar Devnalli to execute the order. Further, the company which has to refund is also before this honorable court, my lords. If they are able to refund the amount, the contempt can be closed.
My lords, one more submission. The Tehsildar has filed an affidavit, compliance affidavit, stating that they have not found any shred of evidence or any movable or immovable property in the jurisdiction, which is a false submission which they made, my lords. I am producing this memo, which has the images. One second.
Affidavit may be kindly looked into, my lord.
My lords. So I have the images of the office where they're located. There are several amenities which can be attached, my lords, which have not been done so.
If
This
they
is
provide the details, I'll advise the Tahsildar to look into the same, my lord.
My lords, details were provided. They have not acted upon it. There are close to
There are 3 of the compliance affidavit, my lords.
My lords, if I may make another submission.
So
my
we are
lords.
open. If the details are provided, I'll advise the Tahsildar.
What will you do?
My lord,
If the details are provided. What will you do?
we will verify if the ownership is vesting with the accused respondent. We will take necessary steps for attachment.
We're talking about the movable assets, my lords, which are already there. They have gone verified, but I don't know what under dealing is. I don't know. I don't get into that, my lords.
We have also covered the tissue in para 3 of our affidavit wherein we have told.
It is your role entirely, not the Tehsildar's responsibility.
DC is the supervising authority, my lord.
Who?
DC becomes the supervising
Deputy
authority.
Commissioner. Deputy
Very much, my
Commissioner.
lord.
That is what we are saying.
My lord,
That is exactly we are saying. That
I
it is,
will take it up with the DC to instruct the concerned Tahsildar to take
no.
steps.
Tehsildar will not, may not come into it.
My lord, it's been delegated.
So
to
you
the-
need some information before you can authorize the Tehsildar
Very much.
to execute. What information you
My
want?
lords, according to our search, the jurisdiction, para 3 of the affidavit, my lords, it's self-explanatory, my lords. Only para 3 I will read out.
Well, there's a copy also is not served on us, my lord, of the affidavit.
Not served. Served.
If not served, I'll serve the same, my lords.
We also don't. We also don't. Yeah. Yes. Give copy then.
Now I'll serve, I'm serving it now itself.
So my lords, one more submission here, my lords. This
Then
is
you
a
go
very,
through the affidavit.
yeah, but apart from this, they're close to around 750 crores due to the home buyer through RERA orders. In every case, it's just not this case, my lords. Every case, the DC or Tehsildar come up with some excuse, and this seriously needs to be looked into, my lords.
Present contempt, my lords.
Consider, let us see. You copy. Given copy of your reply.
Just
now
the
served
copy,
it,
my
my
lords.
Since
That
copy
they-
of the reply is served on the petitioner today, the contempt petition may be listed next on 24th of April.
My lords, I'm actually traveling some other date, my lords.
Tell your date. After
After vacations.
After vacations, send over to 12th of June as requested by learned advocate for the petition.
Case number 36. Maitri Krishna.
But on the last date, the respondents had sought for time to file their reply.
Just wait for time for, hearing the office objection. Just wait for time for hearing of the office objection. I filed my objections yesterday.
We will comply with you.
They have to comply, we are the recovering authority.
When you
Amount is to be paid by
is
accused number 5.
Amount has to be paid for respondent number
Payment.
5, my lord. Amount has to be,
payment of salary,
no, my lord, the amount of compensation that has been awarded by the labor court.
compensation.
Please, my lords. And the recovering authorities are respondent 1 to 4, my lord.
Labor code.
Just pray for time, I file my detailed objection. Actually, accused number 5 is not at all a party either before the labor court or before the WP number. Is not at all in WP number 3766 of 2024. Now he has been made as a party in the present petition. Further, Your Honor, may kindly tell us the order dated 21/2025 passed by this honorable court. I'll just go through the order. The respondent number 4 shall be added as a party to the present proceeding, and notice shall go to the newly added party. The respondent number 4 in 3766 is the secretary, Your Honor, secretary of the hotel management society, that is the respondent number 4. He has not been made as party. All of a sudden, I have been shown as a director of the said society, and I have been made as implicated as accused number 5. I have not been given any opportunity before making me as a party. Only the secretary has to be made party. It is not me. And more than anything else, the said society is not at all in the functioning state. It has already been wounded up. The same has been considered by this honorable court in WP number. When
And
passing a final
please,
order in
why it-
WP number,
That's the difficulty in finding them. We have issued the public notice also, my lords.
WP number 13323 of 2007, this honorable court has mentioned the same in the final order copy.
Place everything on record.
Yes, sir. And even the labor court has also mentioned in its final order while passing the said order.
25th of April. April. 25th April.
Great. Please. Number 38. B. Ramesh.
We have complied, my lords. I'm filing my affidavit,
It is done.
please.
I have to look at it. I go through it, my lord.
What goes? They must have
These have been entered into.
entered in. That's it. Learned additional advocate. Miss Pramodini Kishan files compliance affidavit with service of copy thereof to learned advocate petition of so and so and so. Full stop. From the contents of the compliance affidavit, it could not be disputed by the petitioner that the directions are of learned single judge are complied with, and the name of the as the name of the petitioner in the Raven records is
Please.
entered into. Nothing survives in this contempt petition. It is disposed of as not surviving.
Grateful.
Pledge.
Here for the accused. No, last installment of 5 lakhs has been paid and the entire amount has been cleared and
No,
What
madam,
has been
no entire
complied
amount has been
proceedings,
paid. As per the division bench order, division bench has directed to deposit the payment till month of February 2024. He has paid up to August 22. From August 22 onwards, there is a due of 8th month. He has to pay the 8th month maintenance.
May I request to Lakshmi kindly peruse the order dated 20th August 24 passed by this court. I was directed to pay 16,60,000 and I have given undertaking to clear the amount. Then to last date of hearing, your lordship permitted me to pay the 5 lakhs installment, which I have duly complied. So proceedings, my lord,
The maintenance was
20th August, 20 August,
please,
order.
please. May I read? I have given undertaking to pay 16,60,000.
Order, 20 August. As per which order?
22, Lord, 20th August 24.
20th August, correct.
20th August 24.
24/1/2025, some order has been came to be passed in view of the memo of calculation filed by me. Could you kindly peruse the order sheet dated 24/1/2025?
So you have paid as per the memo of calculation.
Yes, madam. As per the memo of calculation, he has paid 1,16,60,000, which is up to August 22. From August 22 onwards, till date of this month, there's a due.
Appears to be right.
No, my lord. They have filed an execution petition. Here, this contempt is against the order passed by the division bench dated 28th March 24. As per the division bench order, I am liable to pay 14,40,000. But I have paid 16,60,000 before this court.
No.
And the rest of the amount, execution is already pending. They can.
No, division bench has not mentioned the figure of
You are
the.
liable to pay till February 20.
Yes, madam.
Yes,
Yes.
that is only 36 months, 14,40,000. I have paid 16,60,000 before this
As
court.
per the memo. of
That is
cal- up to-
additional
up
6
to
months.
August,
Extend.
up to August 22, he has paid the maintenance.
They can
From
recover.
August onwards, there is a due.
Execution is pending.
Yes,
Yes,
my lord,
madam.
execution.
Work out.
Yes, madam. This may be noted in the order. I am at liberty to execute these.
Lord, execution matter.
No, this is a amounts to a
No,
maintenance, monthly maintenance.
Any
The
observation?
same also pending for consideration of
Directions
monthly
of
maintenance.
learned single judge which are brought under the contempt jurisdiction were
Yeah, pa-
dated 28th March. Directions of revision bench. 28th March 24, which were passed in miscellaneous first appeal number 3231 of 2021. Reading as under. Yeah, quote करना. Bracketed portion. Page 28, 24. In course of the hearing, of this contempt petition. From order dated 20/8/24 was passed. On that day, memo of calculation was filed by the complainant, which was taken on record. Full stop. The order inter alia recorded as under. So paragraph 3.14. Ordered is 28 and 5. After quoting, the aforesaid calculation was up to 22/8/24. Full stop. Today, when thereafter on 27/2/25, the matter was further considered. The respondent paid the amount of ₹10,30,000. Agreed to pay amount of 10,30,000, out of which ₹30,000 was paid earlier and ₹10 lakh was permitted to be paid in 2 installments.
Yes, my lord.
Full stop. In order dated 27/25, the case matter was further considered and it was recorded that as per the earlier order, the respondent was ready to pay total ₹10,30,000, out of which 30,000 was already paid and balance of 10 lakh was to be paid in 2 installments. Full stop. The granting of further installments was granted and the balance amount of ₹5 lakh, which was left out from being paid from out of ₹10 lakhs as above, was permitted to be paid within 4 weeks.
I've paid them.
Today, when the contempt petition comes up for consideration, learned advocate for the respondent, Mr. So-and-so, produces memo to give the details of payment of the said rupees of 5 lakhs. 5 lakhs.
5 lakhs.
5 lakhs, full stop. The memo suggests that accordingly, the total amount of 16,60,000 has been paid to the complainant towards the areas of permanent element.
Please.
Full stop. The memo is taken on record. Full stop. Learned advocate for the respondent would submit that by paying 16,60,000, he has paid
16,60,000.
excess amount by
Up to August 2024.
Excess for the.
Excess 2,80,000 is remaining.
saying that excess amount is paid.
No, my lord.
No, 16,60,000.
16,60,000 completely paid. They say balance amount.
From the original directions, it could be noticed that the directions required the respondent to pay the maintenance till February 24.
Yes.
Full stop. The aforesaid calculation shows that the amounts have been paid up to
August 24.
August 24.
Yes,
Yes,
August 22.
August 20.
Yes.
August 24. Yes, remaining 8 months is balance. No, every month he has to
Saying
pay.
from August 24
Every
to
month he
till
has to pay ₹40,000.
That view till August
Yes, madam. Yes.
till
duly
From August onwards, there is a due.
overview, the maintenance amount has been paid by the respondent till August 2024.
Yes.
Yes, madam.
So it was further stated by learned advocate Mr. So-and-so for the petitioner. It was stated by learned that execution petition is pending.
Yes.
Full stop. The details given above and the payments made by the respondent marks compliance of the directions of the division bench about the payment.
Yes.
And that as recorded above, the payment is made even beyond the period indicated by the even beyond the period of February 2024. Full stop. The contempt petition is liable to be closed.
As on date, there is a due of.
It is closed. Full stop. All rest of the claims, if any, for future maintenance shall be agitated. Are permitted to be agitated in the execution proceedings.
Yes,
In
please.
accordance with law.
Please.
Where contentions of both the sides are open.
This number 41. Martesh DS party.
Lordship, I am a complainant.
We have complied, my lord.
I am a complainant, number 1.
40 somebody who took time. Compliance is filed.
Please, my lords,
We'll prepone it. Instead of 3-6, give copy to the other side. You are, what is your name? What is your name?
Harshita.
You are appearing
On behalf of GS Proceedings.
on behalf of?
GS Proceedings. Sorry, my lord, first time I will
Appellant. Doesn't matter, you are appearing on whose behalf? GS Prasanna Kumar. Oh. So learned advocate Ms. So-and-so, so-and-so states that the order is complied with and the compliance evidence is filed. It is filed?
It is. Apologies, my lord, I'll just explain.
And
The
the
order was
compliance-
complained, my name is Jyoti, same office, order was complained much before they had filed the contempt petition, my lord. So we had filed the statement. of
States that same name, states that the order is completed before, even before the even before the contempt petition filed. Full stop. In the morning, the contempt petition is adjourned at the request of learned of the petitioner to 3/6/21. It is preponed to, it is complied with.
It's compliant.
On to 8th of April to be listed at 2:30.
Please.
But you remain present at 2:30.
Please. And with the effect of that, objection has been filed along with the photographs on 22nd.
File it, file it, file it. Zyada hai, I thought 51. Anyway, yes, little fast.
Lordship, they filed an affidavit, serial number 41, Lordship, and complaint number 1. This is a contempt petition. They filed an affidavit. They're going to place my application before the committee on 24/4/2025. But one part of the order, man, Honorable Court ordered 2 parts, man, Lordship. One is placed before a committee and shall issue a shaggle sheet, man, Lordship. They not yet filed compliance for that.
File the compliance.
It's filed on 12th March. It's a subjective order. Para 7, page 13 may be kindly looked into, my lords. Page 13, para 7, my lords.
Page?
13, para 7.
Page 13, para 7.
Page 13.
3, my lords, 13.
Page 3. 13, there is no page 13.
That is the order of this Honorable Court, man.
As along with the contempt petition.
Sir, that is the order. Where is your reply?
Reply is filed on 12th March 2025.
So where is the compliance?
Compliance is at annexure R1, my lord. If it comes within the prohibited distance, no further steps need to be undertaken, my lord. That's why I pointed out the order at para 7, my lord.
They filed.
Disposed of. Now it is over.
Lordship, not comes in prohibited. They told that not comes
You
in.
challenge that order.
No, Lordship, humble submission. They told that it will not comes within the prohibited distance. Kindly come to their reply statement itself, Lordship. Para 3. Page number 5 of their affidavit. I humbly submit that the Taluk surveyor has also issued letter stating that the distance between the land and survey number 14 of the Guladi village, Sulbele Hobli, Hoskote Taluk from Bangalore, Mahanagara Palike, limits is 26 kilometers. The copy of the letter issued by the Taluk surveyor is here with produced the marked as annexure R2. So they were going to consider my application. They filed an affidavit saying that they're going to place my report before on 24th April. But part of the order, they filed an affidavit for compliance, not other part of the order, my lordship. Kindly keep this until issuance of Sagol sheet. This contempt petition.
Lordship, page 13, para 7 of the contempt petition. 1 minute. It's a subjective order. Only if it comes beyond the prohibited distance, we have to place it before the committee.
Is coming with beyond the limit also, 26 kilometers. Not 18 kilometers the limit. They clearly told.
If it is clear that.
It's clear, very clear.
I'll further clarify, my lords, next week any day.
Read it.
It's
We are
very
with
clear.
you.
I'll just clarify on the further steps.
Not necessary, Mr. Counsel. It is, if it is clear that the land in question is not within the prohibited.
You're wrongly reading.
Then only Saguwali sheet.
That's why
That
it is
is
a subjective order.
So now there is this order is passed that is within, it is within prohibited area.
Other part is issuance of Sagol cheat. Kindly keep this contempt petition until issuance of it.
So this, your land is within prohibited area.
No, Lordship. They clear.
Mr.
No,
18 kilometers, it comes beyond 18 kilometers. So it's a subjective order, so I'll clarify whether it's been placed.
He is entitled to Sagoli cheat.
I'm entitled.
I need to clarify and take. You have complied with the first part of the order. As it becomes a eligible person, we'll see that it is placed. I shall state so in next date of hearing.
When you will be able to respond?
Week after next month.
Week after.
Week after.
This is 21st.
Very much, ma'am.
To be listed at 2:30.
Very much, ma'am.
In view that the only second part of the compliance
Very much, ma'am.
which remains to be addressed.
Great Lordship.
So I appear for the petitioners in item 42. So this petition is concerned with the rampant commercialization of a purely residential area as per the extant master plan.
Today,
This honorable
we'll-
court,
We'll take up this on 16th of April.
very good.
Lord, I appear for the respondents. I request the Lord, the Lordships have posted it for today. Because my application for quarrying lease languishing from 2012, it has been granted. Even the revisional authority has held in my favor. My Lord, the filer writ petition as against that.
No urgency. Any urgency?
My application was pending from 2012. It has been granted by the authority also.
You are petitioner?
I'm for the respondent.
No, then.
Urgency, the Lordship, I have this. Lordship, I have April, my Lord, in any, about the first week of or second week of April. my Lord.
17th April.
Please.
Case number 44.
Nobody is present. 44.
5 minutes.
Follow. Nobody is here. No. So not pursuant to order dated 19 to 25. No further development is shown by the office. In that view, adjourn to 16th of June. On that day, official submit a report whether a substituted appearance is filed.
Number 45.
The notice is awaited, my lord. Notice has been.
Awaited. Notice,
Who is
let
not
the not,
aware?
let the service be noticed is, let this notice be served as it is awaited, stand over to after
Anytime,
19th of June.
please, grateful.
Some objections raised on the wakalat filed by
46.
respondents. I shall comply with that, your lordships. There is some objections raised in the wakalat.
All right,
I
office
shall
to
come.
examine the objections regarding Wakalama. The registrar judicial to examine the objection raised regarding Wakalama and submit a short report on the next date, put up on 23rd June. Yes, next.
That's actually for the appellants. In this matter, we filed a memo, my lords, for dispensation of notice to R7 to R81. My lords, they were the co-petitioners, my lords, before the learned single judge. Since we could not find them, we have made them respondents. So I'm requesting this honorable court to, my lords, dispense with notice, issuance of notice to R7 to 81. Then the notice would be complete, my lords.
For 7 and this one 8 are the original.
7 to 81 minutes.
To whom it is prayed by learned advocate Miss that the notice, issuance of notice may be dispensed with. Full stop. Memo is filed.
Yes, please, my lord.
Memo is filed in this regard with figures on record. Notices to respond 7 and dispense with.
If there is delay of 140 days, my lords, if it is condoned and it is listed for hearing, my lords, this would be ready. We could hear, my lords.
All other are appearing?
All of them are appearing.
All other are appearing.
Government is there and Mr. Bipin Hegde appears for the society, my lords.
In view of the above, the delay condonation application is taken up. Full stop. Allowed.
Yes, please. A date.
कितना लिख के मुझे दे देना.
Any date could be fixed.
After.
Anytime, anytime.
20th June.
Great.
For the applicants, my lords, the notice is awaited, my lords, but there's a matter of urgency because
24th June.
my lords, at least a shorter accommodation in April because I've sought for stay, my lords. They've initiated contempt in case 80, my lords. So it has to be heard because I'm seeking for stay, my lords. So shorter accommodation.
Shorter accommodation. 28th of April.
Second week of April at least, my
Second
lords.
week of 24th April. There is no time, Miss Madam. Yes.
Great.
It is already adjourned.
Not, sir. Some inconvenience to senior counsel. Rajesh
Inconvenience.
Malik, sir.
24th of
Next week,
April.
my lords.
24th of June.
My lords, next week, next week, one day.
Not possible, madam. Well, even delay is there. Not delay, but next.
Serial number 53.
Yes.
I think it's been adjourned. But the notice has been served. There are only 2 respondents. That is only Pollution Control Board, my lords. It may be had any other day. There's no urgency as such.
June, 25th June.
That's it. Maybe had in the regular list because your office objections.
To be listed on regular list.
Interim order.
Office objections are over.
Grateful.
Interim order, madam. Interim order is there, madam. Kindly extend interim order, madam.
Pardon?
Interim order is there, madam.
Interim order is there.
Yes, madam.
Interim order shall stand extended till the next date.
Number 55.
24th June.
This objection with council submission 56.
The learned counsel for the petition shall do the need to comply with the procedural aspects. So all those are like, all the one. Yes.
Submissions is there, we can direct
There is
dispensation of the office objection. That's and post for it.
both 57, 58, 59,
But serial number
58,
58,
57,
my lord.
59.
Lord, serial number 58.
For the time being, the office objections are dispensed with. The appeal shall be listed on 16th of April, subject to further orders regarding office objections. Same order.
I request for 58, my lord. The office objection is, my lord, with respect to annexure D is overruled.
Or
Earlier date,
it is done. Which earlier date, Mr.?
any earlier date. Surface petition, my lord, is entertained by the.
Take chance on 15th.
15th of April.
59, my lord, I appear for the appeal. Serial number 59.
Yes, what do you want?
No, any date, my lord, date maybe.
After vacation? On 26th of June.
Yes.
What about withdrawal? Withdrawal matters may be listed on 2nd of April at 2:30, 60 and 61.
Even the contempt on 2nd of April, my lord.
On that they will dispose,
Very
all
much.
4 matters.
Very much.
The complaints is
The body is over. Very good.
of June.
April work can be done.